Hi, and welcome to our webinar, Lifecycle of a Case, Litigation Insights for Summer Associates. I am Ryan Fermpazzulli, Staff Assistant for the Institute for Energy Law, which is an institute of the Center for American and International Law. Today's program is hosted by the Law School Outreach Subcommittee of IEL's Young Energy Professionals Practice Committee. This webinar is the third part of a three-part series of webinars designed for summer associates. Our moderator today is Gabe Oxford. She is an associate at Pillsbury, Winthrop, Shaw, Pittman in their Houston office. Her practice focuses on resolving complex commercial and industrial construction disputes through litigation and arbitration. I will now turn it over to Gabe to introduce the panelists.
Hi, everyone. My name is Gabe Oxford, and I'll be moderating the panel discussion today. I have the honor of introducing our star-studded panelists. Joining us today, we have Ben Godslin. Ben is a partner in the Houston office of Baker Botts, where he focuses his litigation practice on energy, environmental, mass action, and real estate matters. He routinely advises oil and gas industry clients in federal and state courts in disputes involving industrial accidents, toxic tort claims, contract claims, property damage, and wrongful death claims. Ben was also a member of IEL's 5th leadership class. We also have Andrew Good of Oliva Gibbs. Andrew joins us from the Columbus office of Oliva Gibbs, where he is a partner. Andrew is an experienced commercial litigator who routinely represents oil and gas companies in litigation and arbitration matters. We also have Tracy Glenn. Tracy is a partner in the Houston office of Cokinos Young, where she specializes in complex commercial litigation, insurance defense, and appellate matters in federal and state courts. Tracy has an impressive track record of success representing corporations and individuals in defense of claims relating to construction defects, premises liability, contract disputes, and professional liability. Last but not least, we have Cedric Scott. Cedric joins us from Chevron, where he is senior counsel in Chevron's International E&P litigation unit with more than 16 years of experience in the oil and gas industry. During his tenure at Chevron, Cedric has worked primarily with upstream and corporate business units in managing litigation matters and providing advice and support related to evaluation and management of claims, risks, and exposure. So with that, and without further ado, I'm going to pass it over to Ben, who's going to start our discussion.
Hey, everyone. Thanks for joining today. And so, as Gabe said, everyone on the call has a litigation practice, and so that will be the focus of our discussion today. And as the title for the webinar suggests, life cycle of a case, that's kind of what we'll cover. And we think it's hopefully going to be interesting and useful for you all as summer associates, because we know that while you get some great experience as a summer associate in terms of getting to do interesting research, maybe getting out to see a hearing or a deposition, you may not get the full picture of what the case looks like. And so that's kind of our goal today, to cover that, obviously at a very high level, since we only have an hour, to kind of walk through what are the steps from day one, the case comes in the door, until the date of trial, so that you can have that perspective as you kind of think about your projects that you're working on. And also as you begin your career as an associate, hopefully this will be useful information as to what you're getting into. And so we thought a good way to start this would be with a scheduling order, which, if that's something you're not familiar with, that's basically an order that will be issued by the court very early on in your case. Depending on which jurisdiction you're in, they can be in different formats. Sometimes they come automatically. Sometimes the parties have to request it. But by and large, you will have this scheduling order, which basically gives you certain deadlines to do various tasks leading up to your trial. And the scheduling order is what sort of dictates what happens on the case. And as a litigator, it's also going to dictate your life to an extent, because there will be phases in a case that are busier, some are slower. And so it'll also be very relevant to your workload. And a lot of the things you do are kind of keyed off of deadlines that the court sets in terms of when you have to file certain motions, when you have to do different types of discovery. And so understanding the scheduling order and the things that are covered in it will give you a good sort of overview of what you'll be getting into with a case. So what I was going to do real quick, and we won't cover this in a ton of detail, but I'm just going to share my screen so you can see. Can folks on the Zoom see that? Yeah, okay, thanks, Gabe. So this one is a form that I pulled from the Southern District of Texas, the federal court. No magic to that. This is federal, and I figure we might have folks in different states, so this would be one that, you know, is going to look pretty similar to what you'll see. And as you can see here, there's different deadlines that you'll have to meet, in the court with consultation from the parties. Will fill in these dates, right? So this one's blank. Obviously, you're going to have dates. And in general, this is kind of going from the first thing you do, adding parties, amending your pleading. So that would be your, you know, the petition or the complaint that you file if you're the plaintiff, or your answer as a defendant. Then you've got dates for your experts. When do you have to identify them and produce reports for your experts? When do you have to complete all your discovery? So that would cover written discovery, like interrogatories and requests for production. It would also cover your deposition. So you'll have a deadline when all that has to be completed by. And then there are various motion deadlines as well. Usually a court is going to require you to mediate or do some kind of alternative dispute resolution to see if you can't settle the case, because they have a very busy docket and they would be more than happy to not have your case on it anymore. So that's certainly something that's encouraged in almost all courts. And then as you get closer to trial, there are going to be deadlines for pretrial submissions, which we'll talk about. And then ultimately docket call is sort of right before trial, where you're going to be discussing the various specifics of the case with the court heading into the trial. And so I'm going to stop sharing screen now, but just wanted to put that up as kind of a roadmap of sorts for the discussion today. And so that, you know, this is the kind of document that you'll see in basically every case, and it will set the calendar for the case, and it will set kind of the schedule for you as the team of lawyers working on the case for your client. And so if you're an associate on a case, what's kind of your role, right? So you see this document, it's got dates on it. You know, somebody, a paralegal or maybe a legal assistant is going to calendar those deadlines for you. And then what does that mean for you? And I think as an associate, you kind of have a couple of key roles. And these are things that, you know, maybe things that would be something that would be expected of a slightly more senior associate. But if these are things that you can keep in mind early on, I think you will kind of set yourself apart as kind of an all-star type associate that people are going to want to start going to for work. And so one of the things is keeping up with the deadlines, right? So if you see, hey, we've got a deadline for, you know, a motion for summary judgment that's, you know, 2 months from now, you might want to talk to the senior associates or the partners on the case to say, I see we have this deadline coming up. Are there things that I can be doing to help you get that prepared? Things like that, right? So if you can kind of be proactive about the case with the deadlines coming up to make sure that nothing is slipping through the cracks, that is a huge help to the rest of the team. And the other thing is, as one of the associates, I think it's key that you know the file better than anyone else, right? So if you are the person who knows the discovery documents, you know the motions that have been filed, you can really make yourself an indispensable part of the team. And I think that's something that an associate at any level can do, right? Because if you are reviewing the documents in the first instance before they ever get produced, or looking at what the other side sends to you, and you really engage with that material and understand it, you're going to be a person that partners and more senior associates will really start to lean on, and that will allow you to sort of advance more quickly in terms of the type of work that you get to do. So that's kind of associate, and then I'll talk big picture about things that you're going to want to be doing at the beginning of the case. And I think, and I'll say this generally, obviously, if you're the defendant or the plaintiff, there's going to be slight variations here. But either way, you know, a client is going to be coming to you and saying they have some kind of legal problem. You know, they want to file a lawsuit because they believe they've been wronged in some way, or they've been sued and now they need defense. And so at the very beginning of the process, you're going to need to engage in just gathering information, right? And there are kind of two key sources. There's people, the witnesses, and there are the documents. And so you need to be, and this would be obviously a team effort, not just you as the individual associate, but the team will need to be working with the client to understand who are the key people that were involved in this transaction or this incident, whatever is the subject of the litigation. And what are some of the key documents? What's the key information that is at issue here? So that's what I'd call kind of the fact gathering side of it. And that you need to start right away. Like if you're the plaintiff, that starts even before you file a lawsuit, right? And then when you're the defendant, as soon as you get it, you're starting those things. And the other piece of this is the legal research. So, you need to know the facts and you need to know the law at a very basic level. And so if you are going to be asserting claims, you need to know, what are the elements of those claims? And so that you can understand what are the things you're going to need to establish, because that will dictate what information you are gathering from the client and what things you're asking them for. Because, some clients maybe have large in-house teams, like Cedric and his group are obviously very sophisticated. They know how to handle litigation, and so they can run some of that stuff themselves. Other clients, maybe are not involved in litigation as much. And so you might need to prompt them to say, look, these are the types of things that we need and that we need you to help us gather for the case. And all of that, the fact gathering and the legal research will ultimately go into your initial pleadings, which is, the petition or the complaint. If you're a plaintiff, they're called different things depending on what jurisdiction you're in, or your answer, or maybe it's a motion to dismiss or some other preliminary motion on the defense side. And the better job you do of kind of initial fact gathering and initial research, that will set you up well to have your pleadings on the right path from the start of the case and have you working in the right direction. And so that's kind of the overview for where we are, the beginning of a case, getting it on file. And so now I'm going to turn it over to Andrew, who's going to talk about the fun process of discovery.
Thanks, Ben. So discovery, kind of coattailing off of what Ben said, it's what I like to call the puzzle phase. You've met with your client, you've received documents from your clients, you've got the outline of the puzzle. You understand what's going to be happening, and now you need to figure out how to get the remaining pieces of that puzzle together. And in doing so, you do it through discovery, which is written discovery, depositions, or you can use subpoenas to third parties. And what's revealed in the discovery will really constitute the facts that are used to question witnesses at deposition and ultimately be allowed at trial. So mastering the art of discovery and knowing the facts can provide key opportunities for junior litigators to play a critical role in shaping the client's case for trial. Now, in terms of drafting discovery requests, these are routinely handled by junior litigators, and they're, critical to a case in helping shape both the facts and strategic decisions moving forward. Starting with requests for productions of documents, which these are used to obtain documents from the opposing party. These provide and offer an unfiltered view into the thoughts and activities of the opposing party. So requesting the right documents and carefully reviewing those documents to find the relevant facts can lead to creating a great foundation for the whole case. However, these need to be well planned. Think about the facts that will help you prove your claims or support your defense or counterclaims. And you need to know what the legal standards are for your claims. And in doing so, you want to make sure those requests are tailored and clear. Tailored requests are generally more defensible if they're challenged and can also avoid subjecting your client to equally broad requests. Also, courts are not fans of scorched earth, ask for everything type of discovery with no reason or basis behind it. So if you think of something that's potentially relevant or could lead to relevant information, ask for it and be prepared if you're going to have an objection. Avoid using vague terminology. My position is try to limit subparts or clauses and try to make them succinct and clear. The rule of thumb I always give is split up a complicated request into multiple separate requests for the sake of clarity. And if your opponent objects to the request as vague or overbroad, meet and confer. Call them up, explain why, send them a letter, follow the rules, and keep pushing to get the information or documents that you want. Another key is to always consider how your client would be prepared to respond to similar requests. Meaning, if you're going to ask something that's going to be tough, expect that opposing counsel is going to similarly do the same thing. And if it's something that may be a touchy point or a bad point for your client, try breaking it down or address it with your client so that a proper response can be done from our side. So interrogatories, so these are the alternative. These are used to gain responsive information. They're useful to obtain technical and precise factual information, such as identifying witnesses, locations and dates, obtaining expert witness information, or helping to provide a basis to better understand documents or focus for depositions. Generally, rule of thumb, they're not helpful if they're used to obtain long narrative responses. We want short, concise, and avoid objections such as a narrative response. Keep in mind that a lawyer will be answering this. Obviously, the opposing party or the individual will be signing off on them, but you also want to be able to ask who, what, when, where, but not why. And that's based on the light of the Civil Rule 33, which permits only one set of interrogatories to be used. So you need to carefully develop these and ask for the right information and know what information you need to know. Request permissions, that's the third set. These are basically statements that you ask the other party to admit or deny. You want to use these wisely. These are generally used to obtain facts that the other side has no basis for disputing. So an example would be whether a specific document was made and kept in the ordinary course of business, whether a signature on a certain document is authentic, but you really want to avoid any disputed key elements. You're just never really going to get an admission from that. It's always going to be an objection, and then you're going to have to fight for that in court, which generally doesn't go in favor. So that's why you need want narrow and targeted requests. So again, avoid legal conclusions, highly disputed issues. And I'd also say, and I've been a part of this, inflammatory language. That's just never going to get anywhere. It's always going to cause problems between not only the attorneys, but the parties as well. And so additional tips on writing these, understand the types of objections that can be raised in response to your discovery requests, right? Refer to your pleading. So if you drafted a complaint as a plaintiff, use that similar language. If you produce a counterclaim, use that similar language. Refer to jury instructions to find out the elements of the causes of action so that you can use those in writing your discovery requests, because that's ultimately the key in what you're going to need to prove at trial. Know the type of information that can be obtained from the opposing party or from a third party. And before finalizing, review the discovery request and play devil's advocate. How would you respond to these? Are they just going to be objectionable, or are they not going to respond? Think about that before sending them off to your client for review and for final submission. Now, flipping it, responding to discovery requests. You want to read all your discovery requests first and foremost, kind of give a flavor of what they're asking. Know your client's deadline to respond and produce those documents, and then be thorough in responding. For me, I like to start by responding to interrogatories first. They're generally straightforward, easy to answer, and kind of gets the ball rolling in terms of responding to all of them. You want to answer these as completely, as thoroughly as possible. Complete sentences are generally the most appropriate, but some certain questions may allow you to have shorter, concise. You can reference documents if you want to answer to an interrogatory, but have those documents available to be produced. You can cite to those. Do not summarize the document, simply reference them. Obviously, the interrogatories and the documents, these need to be signed or heard, so it's important that you have written answers that are accurate. If a question is confusing or you believe it'd be helpful to speak with a client, do so. Just highlight that question, go talk with a colleague, or call the client and talk with them about it. And only answer the question that is asked. This is not your opportunity to tell your client's story. In crafting your answers, you should read the questions carefully, refrain from providing a narrative style response that provides more information beyond the scope of the question. For RFPs, which is request for production of documents, each request will ask for a certain type of document. Some may overlap and some may not be applicable to your client, but the client is required to produce all requested documents that are in its possession, custody, and control absent any type of objection, privilege, or confidentiality. If a document doesn't exist, mark that, note it, talk with your client. And again, review before producing any type of documents, because you want to make sure that you have redacted what needs to be redacted and you've held back what's confidential or privileged information. And remember your duty to supplement as you move forward in the case, and always talk with your client about that. RFAs, couple few tips for request for omissions. If something's not really in dispute, don't give an invasive response that will embarrass you when it's read to the jury and judge. If part of a request for omission is true and part of it is not true, respond clearly on what aspects are admitted and which are denied. And remember, if you fail to admit something or respond appropriately, but later your opponent proves the document or the information to be true, that can, although it doesn't always happen, lead to sanctions and seeking reasonable expenses for making it provable. Lastly, in terms of responding objections, know your objections, know how to present those objections, and present them accurately. Now, one thing, there's losing objections, winning objections, and we need to know the difference. One is general objections, everybody ignores them. That's just kind of the rule. Objecting to everything that is not relevant onto the subject matter or likely not to lead to admissible evidence, those are no longer the standards. But presenting winning objections, so if it's an unreasonable amount of time or money to fill the request, or if it's not related to any claim or defense, or there's no reason to go beyond the ordinary scope of discovery, take your time, explain why, give justifications, and that will allow opposing counsel to review that and either meet and confer or go to the court, but you'll be better prepared. Now, the second part of this is depositions, and I'll cover deposition prep and defending depositions. And we'll kind of go through these. For deposition prep, you need to know the law, and you got to keep your client's theory of the case in mind. So you need to know what questions to ask, and to do that, you need to know the law, and you need to know the facts. And so the second part of that is learn what objections are acceptable. So which are permitted, and it depends because every jurisdiction has different rules regarding objections. Be organized. Consider the sequence of your questions and be sure they are fully prepared. Organization will help you make sure that you cover all the topics, and if it goes accordingly, you may go off script and allow the witness to testify, but you'll be able to go back ultimately to your script to be able to cover everything that you need to cover. And when that happens, the thoroughly prepared outline and your knowledge of the facts and the documents will allow you to get right back in line and cover those pertinent topics, or be done with it and move on. Defending depositions, be the most prepared person on the facts in the room. Know and understand proper objections. Avoid the frivolous objections just to object for objection's sake. One of the things I like to always say, and I'm sure we could talk about this for a whole hour, is understand the difference between set of questions versus purely factual questions. So hypotheticals that are asked to your client, knowing well down the road that they're going to bring that exact hypothetical up to kind of kick your client's legs out, say they don't meet. Prepare your client for deposition. Take your time, take as much time as needed to prepare your client. Do not wait until the day before the deposition to prepare. You have to understand that these depositions are nerve-wracking for any witness, including clients. And the more prepared they are, the more comfortable they are with you in the room, the better experience they will have, the better the outcome will likely be, and the better client service you'll be providing to them. And then protect your client. Be mindful of the pace. Don't let your client get run over by opposing counsel. That's managing the pace of questions, making sure your client understands the questions that are being asked, taking breaks when necessary if your client is getting ahead of themselves, allow some collegiality between the parties and the two attorneys, and do not obstruct, just obstruct. There's a whole host of rules that I can go through, but the one is, a couple of them are answer the question that's been asked. It's not the time to tell the client's story. Tell your client to pause before answering because you may need to object. I don't know. I don't recall are perfectly acceptable answers if they're true. And if you don't understand the question, ask that it be rephrased. Try not to talk over one another, and be aware of compound questions. And listen to your attorney. It's one thing that I'm sure everybody on this line has dealt with, where they've prepped a client and they're not listening to you. It's a runaway client. So, and then come back, stay calm, keep your client calm, tell them they're doing a good job, and tell them to always tell the truth. And I know Ben briefly touched on the young associate's role in discovery. I think it all depends on the firm you're with. You could be with a small firm or be out on your own, where you're handling everything, or you're thrown right into the fire, or you're building up and you're working with senior associates of counsel and then partners. So your experiences could be from day one you're doing this to multiple years down the road. That's when you're getting into it. But with that, I will turn it over to Tracy.
Okay, so I'm going to talk a little bit about Darbert Motions and Dispositive Motions. So after you've gotten all this great information through the course of discovery, you want to see whether or not you can strike an expert, which is your Darbert motion, or if you can maybe get a case dismissed or a claim dismissed, and those are your dispositive motions. So Darbert motions basically is your request to the court to basically either strike the expert altogether or strike portions of their testimony. They're named after Darbert because this is a case that basically provided the standard for what courts will look at in terms of whether an expert is qualified. Darbert basically says before an expert is allowed to testify, they must be qualified, their opinions must be reliable, and they must assist the jury, right? Your case can either sink or swim with an expert. So it's really important that you get the right kind of expert, because the right expert can help you get a great settlement, or it can actually get your expert struck, and then you're really in bad shape. So basically you look at whether they're reliable, whether they have the qualifications, and whether you're retaining an expert or if you're looking at the other side's expert, you still need to ask that question. Before you go out and get an expert, you need to look at his CV, his resume, to see whether or not he's actually qualified. And when we're talking about qualifications, it's not necessarily how much academics or education you have. It could be your experience. You don't have to necessarily have 10 years of academia to be an expert. You can have 15, 20 years in the industry and know more than someone that may have a master's or a PhD. So that's what a court will look at, is whether or not the expert is qualified. You also have to kind of be able to understand that not all experts are created equal. So if you got a personal injury case and say that plaintiff suffered a paralysis, right? Well, you probably are not going to get a general practitioner or oncologist. They're not going to be qualified. They might be brilliant, but they're not the right kind of expert. If you got a plaintiff that suffered a brain injury, you're probably going to need a neurologist, not a cardiologist. So you have to make sure you have the right kind of qualifications. And then you need to look at whether or not he can be really smart, but is his methodology flawed? And so with methodology, and I won't go through all the steps you have to take, because every case is different, every expert is different, every set of facts is different, but you want to basically look at not just the opposing side's experts and whether or not their methodology makes sense, but whether your own expert's methodology makes sense. And that's when your expert can come in handy when you're looking at another expert. When you get that expert report from the other side, get with your own expert, sit down with your expert and have them look at that report and make a determination of, okay, what should we be critical of? Is their methodology flawed? Are they relying on the wrong information? That's another thing with discovery. With expert discovery, you usually will get the entire expert's file. And usually it's everything that attorney sent over to the expert, right? But just because 1 million pages of documents were sent over to an expert doesn't mean they necessarily reviewed it. And it doesn't mean they relied on it in arriving at their own opinion. So you really do need to determine what the expert relied on in arriving at their opinion. You need to figure the same out with your own client, because a lot of times attorneys will send over the entire file or a big bulk of the file over to their expert. An expert doesn't necessarily need everything and may review it, but doesn't necessarily rely on it. So you need to get with your expert, find out what he's relying on to come to his opinion, and see if he's relying on the same kind of information and the same documents that the other side is relying on. If they are relying on different information, you need to determine why that is. And that may be a flaw in your own expert's methodology, or it may be a flaw in the opposing side's methodology. The other thing you want to do when you get an expert, as soon as you know about the opposing side's expert, go to Westlaw, pop their name in Westlaw and see whether or not they've been struck before. That's the easiest thing to do. Even if they haven't been struck, I know there's a feature on Westlaw that you can actually pull up expert materials. Look at their old depositions, see if they've taken a contrary view in a different case with substantially similar facts. So you want to make sure you just leave no stone unturned, because this is the kind of information you need when you want to draft a Darbert motion. The other motion that's very helpful and that a lot of people file are the motions for summary judgment. Now we call them dispositive motions. Dispositive motions aren't just summary judgment motions. They're your motions to dismiss, your motions for judgment, your default judgment. I'm going to focus more on summary judgment motions. I know a mentor of mine, one of my partners here, he would always say at the beginning of the case, draft a jury charge before you send out discovery. Not only will it tell you the elements of the causes of actions that are being asserted and the defenses that are being asserted, but it will also tell you what questions the jury will have to answer. So if you have a jury charge, that can be a great roadmap in terms of what questions to ask in discovery. I still do that, but I will go one step further. When I am doing discovery, or if I'm instructing or helping an associate draft discovery, I always draft discovery in terms of what information do I need to either get a case dismissed or to defeat a summary judgment. Again, go to Westlaw, pull up cases that have substantially similar facts, same causes of action, and look at the cases where they've granted a summary judgment. Look at the cases where they haven't granted a summary judgment. Look at the issues or the facts that the court thought were significant in either granting the summary judgment or denying the summary judgment. And you want to make sure whatever information you learn, good or bad, your client is aware of it. And this will help him when you're presenting them for deposition, and it'll help you when you're trying to defend against the deposition, right? So you want to make sure you know not just the good, but also, the not so good in terms of moving for summary judgment. In terms of the tips I would give you in terms of summary judgments, keep in mind that the goal in a summary judgment doesn't always have to be to get it granted. Sometimes a summary judgment is used to educate the court. Sometimes you already know there's a long shot, but you can educate the judge in terms of what the issues are. And even if he's necessarily on the fence about granting the summary judgment, it's something he'll carry forward. So even if you have to end up trying the case, he's looking to see if the plaintiff or the defendant ever came up with additional evidence to warrant the case actually being turned over to a jury in the long run. The other thing is, if you have a mediation scheduled, you may want to file a summary judgment to encourage settlement if you haven't got a ruling on it yet. Sometimes just having a summary judgment pending puts some pressure to try to get a case resolved. In drafting the motion, I would say the biggest mistakes that I see associates make is citing straight from OConnors without any verification. OConnors has a lot of great information. It's a great starting point, but there are mistakes in OConnors, and you can always tell the ones who just basically did a plug and play and took the information out of OConnors and did not shepherdize the case. didn't read to see whether that case was actually in their favor. And that kind of leads me to my next pet peeve. Oftentimes you will see briefs, and it's not just summer associates that do this or young associates, but seasoned attorneys will do this as well. They'll see a snippet in a case and think, wow, that's a great language for me, and then not read the entire case, and the case actually goes against them. So, the long and short of it is you never want to cite to a case that does not support your position in the long run. It might have some great language in there, but, there may be times that you have to cite to a case that is not necessarily in your favor, but you need to be prepared to distinguish it. That's the other tip I would give. Shepherdize not just your cases, but also shepherdize the opposing side's cases. You need to be able to distinguish any case that clearly undermines your position. You don't want to draft a Darbert motion or a motion for summary judgment without recognizing that every case is not going to be for you. That just rarely happens. So, but you need to be able to know how to pivot and say, hey, that's a great case, but this is how that case is different from our case. The next tip I would give is when drafting any motion, you always lead with your strongest argument. The court should know in the first paragraph what you want and why it should give it to you. And there's nothing that drives me crazier than getting an associate's brief that's 20 pages long, and on page 5, I still have no idea what they want. And if I'm thinking at the court who sees dozens and hundreds of briefs, they don't want to see a novel and still not know exactly what the case is about, why they should grant you any sort of relief. You need to be upfront, straight out the box. This is why I'm entitled to a summary judgment for X, Y, and Z reasons. Or you should strike this guy because he doesn't have this and he said this and they said that. So at least after that, the court is now seeing if everything you've written after that first paragraph, you've supported it, but at least he knows where you're going. So in the first paragraph, you should really be educating the court on exactly why you're entitled to the relief that you're seeking. If you have a case that's directly on point, don't just cite to it. Include some examination of the case. Explain how your case is similar. You can say, hey, these are the same arguments that are being asserted by the plaintiff that were rejected in XYZ case. There's nothing to distinguish that case from the case before the court. Judges love that. If you give them a factually similar case, that gives them an excuse to grant whatever you're looking for, at least give it some serious consideration. If there's a great quote from the case, I always tend to lead with a great quote from preferably a Texas Supreme Court case. I start the paragraph with it. If it's in my favor and that case is soundly behind me, there's nothing better than using a court's language that's in your favor, because that grabs the court's attention. Courts don't want to be reversed, and that's why these motions can be tough, but they also don't want to waste time with cases that have no merit. So if you give them enough strong language from courts that are directly on point, preferably the one out of your district, that'll give them a reason to go ahead and grant these motions. I would also advise that before you give any motion to a partner, read it, reread it, and reread it again. And if time permits, leave it a day or two and come back to it. There's been many times when I've been drafting a brief and I'm thinking to myself, wow, you're brilliant. Why aren't you on the Supreme Court? This is outstanding. And then 2 days later, I look at it, I know why. So you go back and that's when you catch your mistakes. That's when you say, okay, with fresh eyes, maybe this doesn't sound like the best argument, but you just make sure you're always leading with your strongest argument. And I would say the final point I would make is that whether you're filing a Darbert or a motion for summary judgment, just remember that every failing you point out in the opposite side or the opposing side can be thrown right back at you. So you need to really make sure you think before you file, that you dotted your I's and crossed your T's. Think whether you can defeat a Darbert motion if one is filed against you. Can you defeat a summary judgment if it's filed against you? If you're pointing out all the flaws in opposing side's expert, you better make sure your expert is not making those same mistakes, because you're going to get a Darbert motion as well. So that would be my final advice to summer associates. I'm going to lead this back over to Ben.
Thanks, Tracy. So, we've kind of been talking about the life cycle of a case. And so we started out with, somebody knocks on your door, sends you an email saying, we've got a problem. You've done the investigation with them, you filed your lawsuit, or you've responded to a lawsuit where they're the defendant. And then, Andrew, like he talked about, you do all the discovery, the written discovery, depositions, you gathered a bunch of facts, you use those facts with your experts, you filed dispositive motions, and now you're sort of getting to the point of trial. And so that's the part we're going to talk about next, is not so much the, drafting your opening statement, but sort of what are the things you have to do before you get to that point to make sure that you can present the evidence to the jury that you want to present to them. And I think Tracy made a really great point, which is the jury charge. And it's so critical. I mean, that's such a key document to any trial, because it's literally, at the end of the case, the judge is going to read the jury charge to the jury and then give it to them. And that's what they're going to use to answer questions. Was your client negligent? Yes or no? How much money do I award for this category of damages? That's what they're going to use to answer those questions. And so having a good understanding of that document at an early stage of the case is really critical, because at the end of the day, that's really the only thing that matters, because it's the only thing that the jury is going to be looking at when they're deciding whether or not your client's going to win or lose, or what the financial implications of the case are going to be. And so in your trial prep phase, you're going to want to have your jury charge, and you're going to want to understand, what are the causes of action that are going to be addressed in there? What are the elements of those causes of action? And what pieces of evidence do I need to establish my case, either my affirmative case or my defense, as to that element? And that can come through witnesses, or it can come through documents. And usually it's going to be a combination of those two things. And so you want to be able to map out, and people do it all kinds of different ways, but you're going to want to have a chart, some kind of document that lays out for each element of the claim, each category of damages, who are my witnesses that are going to talk about this? What are they going to talk about? What are the documents that we're going to use to prove up the points that we think the jury needs to hear in order to rule in our favor on this particular issue? And the first step is identifying those people and those documents, but then you also have to make sure that you can actually present that stuff to the jury. So if you're talking about documents, you need to make sure that they are admissible. So one example is someone's going to have to authenticate that, right? So you need a witness who's going to be able to say, I know what this document is. I drafted the contract. I'm the person that signed it. I was involved in the negotiations, that sort of thing. Or you're going to need a business record that from a company who generated the document saying this is one of our records that we generated in the ordinary course of business. It's a true and correct copy, all those sorts of things. And so you're going to want to make sure that all your I's are dotted and your T's are crossed in terms of just getting the document into evidence, because the worst thing is you show up at trial and you've got this key document and the other side objects and says, no, they haven't authenticated that, or it's hearsay, or there's some other objection and you're not prepared for it and you can't use that in front of the jury. And so those are things you've got to be really mindful of and have a very clear path as to how, for anything that's important to your case, how you're going to get it into evidence, what objections you might get from the other side, and what your response is going to be to those objections. And then witnesses are the other piece. Probably a fair number of your witnesses are going to be your own, if you're representing a company, probably the employees, the individuals who are involved in the transaction. So those are usually easier, right? Because they're sort of within your control or your client's control. But you still need to start working with those people early. if you've got, usually by the time you're getting close to trial, you're going to know there's a handful of people that are really central to the case. And you want to make sure that they know several months out, hey, here's the trial dates. Make sure you don't schedule, your long-awaited month-long trip to Europe because we're going to need you here for these weeks. Make sure you block them out and explain to them the expectations, right? Are they someone that's going to need to be there the whole time because maybe they're a corporate representative? Or do they just need to be there for one day to testify? What exactly is their role going to be? And really, you go through another phase of preparation with them. So Andrew talked about the deposition preparation, where you're going to do that all over again for the trial, where, it starts with the scheduling, just making sure they know, making sure they have a very clear picture on what their role is, making sure they're comfortable with that. They know the documents that they're going to need to talk about to the jury. And because you're not the only person that gets to talk to them, make sure that they're prepared for questions that they're likely to get on cross-examination when the other side's attorney is asking them questions. But the other piece with witnesses is, you may have some key pieces of information that come from other people that may not be your client or employees of your client. And so you need to be thinking about early on, how am I going to get that information in front of the jury? And maybe it's a subcontractor that you have a good relationship with, and so you can work with them to get them in person. But maybe it's an adversarial relationship, and so you're going to need to subpoena that person to be at trial. Is the person out of state, such that they're outside the subpoena power of the court? These are all things you need to think about and be prepared for, so that you can make sure that for each of the elements of your case, you have the information that you need to be able to present your case to the jury. And then one other thing I'll say on kind of trial preparation, which is not the trial itself, but it's the concept of a mock trial or a focus group, which you're not going to be able to do that in every case because it's an expensive endeavor, and some cases may not justify it. But it's an incredibly useful thing to do as you kind of, you've developed the case through the discovery process, you have experts, you basically know what each side is going to say, and you have your themes and your theories that you think are compelling and very strong. But it's amazing what you can learn when you tell that story to a group of people who have never heard about the case before, and you get their reactions to it. So to me, that is a really critical, central thing to do in trial preparation, to get a true outside perspective on what your case looks like to people who haven't spent the last year, 2 years, 3 years living the case like you have. When you present it to them in a 30-minute PowerPoint presentation and you put your best arguments forward, what do they think about that? It's really, you can understand what resonates with people, what doesn't. And it's also useful for your client to see that too, because they can understand and get a real perspective on the case, both in terms of themes that people like, potential exposure, risk from the case, things like that. So there's a ton of things that can go into trial prep, but those are some key things and very high level. But now I want to turn it over to Cedric, because obviously everyone who's talked so far is outside counsel, but Cedric has a unique perspective that's really important, which is how does the client think about all these things and getting ready for trial?
Yeah, thanks, Ben. And I'll start off by saying that the points that Ben, Andrew, and Tracy have made are all great points, really good points, and I'll piggyback on a few of those. But all the things that they have described over the last few minutes are things that, as an in-house lawyer, I am the sort of first line conduit for providing those materials to the outside lawyers. So when a lawsuit is filed, we receive notice through service that a lawsuit's been filed. My job is to look at that lawsuit, analyze the claims, analyze the jurisdiction, and then try to figure out, is this something that, one, there's a viable claim, something that we need to retain counsel for, and then if we do need to retain counsel, then my job is to identify who that counsel is going to be. So I'm in a unique role of actually interviewing and considering outside firms to come in and represent the company. And typically what I do is I look at the subject matter of the lawsuit. I'm looking for someone who has experience in litigating that particular issue. or particular familiarity with the jurisdiction, whether it be the judge or the state or country, as it may be, where the legal issue is arisen. And then I look at, personally, what I look at is someone who is a trial lawyer. Because if I have a lawsuit, I want somebody who, if we have to go to trial, is prepared to litigate the case. I'm not looking for someone who automatically comes in and is looking to settle the case. The case may settle, but I would much rather settle with a litigator, somebody who's ready to try the case, than to try a case with someone who's never tried a case before. So I'm looking at experience that person, that team, that firm may have in handling issues. And similar to what Tracy was talking about, you do your research on experts. I do the same research on firms. I look at experience that the lawyers have in trying cases. I look at their success record. I look at how many times they tried this type of case. I look at their reputation. Are they somebody who's recognized as being a leader in that field or that industry or that subject matter? And then I also look at who the plaintiff's counsel is, the lawyer who filed the lawsuit. I want to see what their reputation is. Are they someone who is known for being really litigious? Are they someone who is well-versed in the subject matter? Because if they are, then I want to have somebody who is equally or more skilled and more adept at that area. If they have the experience of going against plaintiff's counsel, that's another added benefit. So from my perspective, I do that. And then I say at a high level, my role as an in-house lawyer is probably more in the terms of a translator. And what I mean by that is I communicate to the outside lawyers what the business team needs or what their objectives may be for a specific issue. We may have a deal that has gone awry, and we want to, we have to, have a dispute. We have a dispute over, some issue of that deal. Sometimes, litigating over a deal means you win on an issue, but you may lose on the big picture. So I don't want to torch relationships if I don't have to, but sometimes I might need to. And so what I have to balance is what is the business needs versus the litigation needs, and vice versa. So I also talk to the business team about, okay, well, this is what you want to achieve, but this is what the court system will allow. And so I serve as that conduit for information, both in terms of explaining what we want to achieve and what our goals are from a business perspective, and what we can and cannot do within the legal framework of the court system or arbitration or whatever the venue may be. And so when I'm looking at a lawsuit, I talked a little bit about I want to hire lawyers who are skilled at dispute resolution, at trying cases. If we have to, get into court. What I look at too is what is the cost associated with trying a case? Is it going to be an expensive case? If it is an expensive case, that doesn't necessarily, change my outlook in terms of, do I try to settle the case or do I, go all the way in? But it does make me be cautious and explain to the client that this is an expensive proposition or could be expensive proposition. And so we want to make sure that that's, factored into the calculation of our strategy for going forward. If it's an expensive case to litigate and there's no clear answer, this is a toss-up 50-50, then that may, incentivize the business unit, excuse me, to consider discussing settlement earlier in the case than you might otherwise. If it's a slam dunk case, this is, and no late lawsuit is a slam dunk ever. If it is, it probably doesn't get very far. But assuming that you have a higher degree of confidence that the law is on your side, you may take a stronger approach in terms of your dealings with opposing counsel. You may not engage in settlement talks until you've had a chance to go through discovery and file some of those dispositive motions that Tracy talked about, because you feel that there's an opportunity for you to resolve the case with court assistance in a court ruling that, one, will give you a final judgment, and two, will serve as precedent for you going forward, so that copycat lawsuits aren't being filed, that you don't have other people that are trying to come in and file lawsuits that subject your company to what we call a docket of cases that are being repeated over and over and over again. The worst thing you can do is settle cases that have the copycat potential for being copycat lawsuits, because all you're doing is sending a signal out to plaintiff's counsel or plaintiff's attorneys that if we file these lawsuits, this company is going to just open its checkbook and just write check over, check after check to pay off a case. So you don't want to do that if you have a strong defense. However, if there's a case that you don't have a strong defense, you probably want to try to find a resolution sooner rather than later, so that you're not creating, again, a docket of lawsuits that are going to be filed over and over again. So what I'm looking for when I'm hiring counsel is someone who can help me both in terms of strategizing for the specific case, but then also looking at the bigger picture. You can see that a specific lawsuit can be won or lost, but if it's won in a way that doesn't knock off other lawsuits, then maybe you want to look at how you pick off all the lawsuits rather than just one, and vice versa. You want to be strategic in how you do that. So what I'm looking for in lawyers is someone who could be a partner in helping me sort of analyze the issues both for this lawsuit and then the bigger picture. And then within the law firm, especially with this unit, this group that we're talking to, I'm looking for team members who are partners. I'm looking for associates who can be forward thinking in terms of what it is that might be a risk to me, to my company, and make recommendations on how best to prepare and insulate ourselves against those risks so that we don't have a negative outcome in terms of this lawsuit or any other lawsuits that come about. And so that's sort of a broad stripe, and I'm rushing through because I see we're coming close to the end of the hour. I could talk about this forever, but I promise I won't do that today. So the last thing I'll say for young attorneys advice, and this is not necessarily related to trial, and I think Ben said this earlier, and I know that Andrea and Tracy agreed. In terms of a young attorney, you want to make yourself a very integral part of the team. You don't want to wait all the time for someone to tell you what to do or someone to ask you to do something. You're a part of the team. You're brought into a matter for a reason. If you're on that case, you should treat it as if you're the lawyer on the case, as if you're the only person thinking about it. You should, take time to evaluate and analyze and research and take pride in your involvement in the case. And when you do that, I think it sends a message to the partners that you are interested and you're invested. They will give you more opportunities to do more. Everybody wants to be in court arguing. Some people do, not everybody does. But if you want to do that, sending that signal to the partner that you want that will invite them to give you more opportunities. And those opportunities gives you a chance to be in front of people like myself, the client. When the client sees that you're, providing valuable contributions, they will ask for you specifically to be involved in cases. And when you're asked for specifically, that also sends a signal to the partners you're working with that you're a vital part of the team. And then when you and the partner are seen as a team, then you have a consistent, book of business, I'll call it, where you can continue to develop your skills and become sort of the subject matter experts that when I'm looking for an attorney for a specific lawsuit, I then know your name. I then know to look for you. I then, call you to retain you for those matters. So that would be my advice to young lawyers starting off is don't assume that a project is just a one-off. Get in there, figure out a way to make yourself an integral part of that team to that issue, and then make that issue your own. And don't be afraid to dig deep, because that's how you add value both for yourself, for the firm, and then for your clients.
Thank you all. That was super insightful.